This is Eye on Bankruptcy, brought to you by the American Bankruptcy Institute and Bloomberg Law. Don't forget to answer the polling questions for CLE credit that will appear throughout the presentation. Download this month's course materials here and submit your questions for the panelists here. Now, here's your host, Bill Rochelle.
Thank you, Charlie. That magnificent voice belongs to Charlie Pellet, one of Bloomberg's radio announcers. We're going to run a contest. Those of you in the audience, if you know where you can hear Charlie talk all of the time, other than on Bloomberg Radio, then send me an email. From all of the correct answers, we're going to choose one at random, just like on Car Talk, and that person is going to get a valuable prize. I am Bloomberg's bankruptcy columnist, and at Bloomberg and at the American Bankruptcy Institute, we recognized that the bankruptcy community did not have a monthly current events show, and that's what we're going to bring you on the last Thursday of every month. Our first show in March covered basically the last half of 2014. Today we are covering the first quarter of 2015. In late May, we're going to tell you what happened in the courts in April and May, probably also a few Supreme Court decisions if we have them. And then in late June, we're going to be discussing even more Supreme Court decisions. On our panel today, we have two of the country's finest bankruptcy judges. First, immediately to my right, is Jeffrey Hopkins, the Chief Judge of the Bankruptcy Court for the Southern District of Ohio. Judge Hopkins sits in Cincinnati, and he is an editor of the Bloomberg Bankruptcy Treatise. Judge Hopkins was a football player in high school. He then went the route of academia and went to Bowdoin College, one of the very finest liberal arts and crafts colleges on the face of the earth. After that, he recognized that writing poetry was not a good way to make a living, so he went to law school at Ohio State. After that, he clerked on the Sixth Circuit, and from there it was a stint at Squire, Sanders and Dempsey. Then he was an assistant U.S. attorney, ending up as chief of the civil division of the U.S. Attorney's Office. With that kind of a resume, I think it's just a matter of time before Judge Hopkins is elevated either to the district court or the circuit court bench. And for my money, I hope it's the circuit, because then he would become Ohio's version of Thomas Ambro on the Third Circuit, and Connie Sear on the First Circuit, and Carolyn King on the Fifth Circuit, all of whom were bankruptcy experts before they went on the circuit bench. Next to Judge Hopkins is the Honorable D. Michael Lynn from Fort Worth, Texas. And when I say that Mike and I go far back, I mean way back, because he and I went to law school together at Columbia, where Mike was a recipient of the Harlan Fiske Stone Scholar Award. Mike, I shouldn't say Mike, you're Judge Lynn. To me, of course, it's Mike, and has been now for a very long time. But Judge Lynn is the editor-in-chief of the Bloomberg Bankruptcy Treatise. He wasn't always a bankruptcy judge. He did a stint as a partner in that little bankruptcy boutique called Weil, Gottschall and Manges. And I keep saying it again, Judge Lynn was a lieutenant in the U.S. Navy, and that's why whenever you're in your court, you see that he runs his courtroom like he's the officer of the deck, which indeed he is. Today we're going to talk about, I'd say upwards of 20 cases. We're going to start off with 3 or 4 cases argued in the Supreme Court, no decisions yet, by the way. Then we have 4 cases where there are circuit splits, followed by a number of both consumer and Chapter 11 cases. By the way, those of you who subscribe to Bloomberg Law could already have read about all of the cases we're going to discuss today, because I have written each of them up within days of the time that they were filed. So let's start off with Baker Botts versus Asarco. This is a case we talked about on our last show. This has to do with whether or not a lawyer who defends a fee application can have the defense of fees compensated as part of the that lawyer's recovery of its fees in the Chapter 11 case. I hate to say it, but I happen to think that, as my own personal guess, that the Supreme Court is not going to make that defensive fees compensable. But Mike or Judge Lynn, what are your thoughts on the subject?
Well, to start with, feel free to call me Mike. I've been called worse, and so that doesn't bother me at all. But what troubles me about the Asarco case and other cases that it draws upon is the fact that it's referred to as a fee-sharing case where the American rule should be applied and the winner should pay for his own legal costs. The problem is that as opposed to shifting the fees to the loser, in a bankruptcy situation, the fees are paid by the estate. And it seems to me that the whole concept, however many precedents there are to that effect, that the fees should be paid by on the basis of whether a fee-shifting statute would be applied is simply a mistake in the law. That the reason what we're looking at here is more along the lines of whether a trustee should be paid by the trust which he administered, or his attorney should be paid by the trust which is administered. So I think that that's one of the problems with the Asarco case, though I don't think it has been very strongly put by the parties, certainly not by Baker Botts, and it does not appear that the Supreme Court is going to adopt my view. So we're going to be stuck again with a situation where the law is made in a fashion that maybe was not right, but once the Supreme Court says it's right, well, that means that's the end of the day. We all have to live with it.
That's right. Well, let's hope that one or more of the Supreme Court justices see this show. Let's move on to two cases that were argued together on the same subject. These cases are called Colquette and Toledano Cardona. Those appear at page 8 of your course materials. This is a case on whether or not in a Chapter 7 bankrupt debtor can strip off an entirely underwater subordinate mortgage. Before oral argument, I thought this is a clean-cut case. I thought that the Supreme Court would simply say that their 1992 decision in Dewsnip would apply. That was the case where they said that you could not trim down a mortgage in Chapter 7. The Supreme Court, without really referring terribly much to the statute, simply said in bankruptcy, it has been traditional in Chapter 7 that mortgages always flow through. Well, was I surprised when oral argument began, because it became almost immediately apparent that there is some faction, if not a majority, on the Supreme Court, which frankly just wants to overrule Dewsnip top to bottom. The very first voice that came up on that issue was Justice Scalia. In the 6-2 Dewsnip decision, Justice Scalia had dissented because he said, our decision just does not follow the statute. Among the justices who decided Dewsnip, only Anthony Kennedy is still on the bench. He did make comments during oral argument back at the end of March that he thinks that decision is still correct. But Elena Kagan, one of the new members of the Supreme Court bench, said that she agreed with Scalia's dissent and that the cases at least should be limited to its facts. Justice Sotomayor said that retaining valueless mortgages interferes with the debtor's fresh start, and on that basis, perhaps she sides with the debtor. Justice Ginsburg said that the law would be more coherent if Dewsnip were overruled. Now, it's my personal guess that the Supreme Court is probably going to limit Dewsnip to its facts and simply say that if it's completely underwater, you can strip off in Chapter 7. But the practice point is this. Regardless of where you are in the country, if you have a Dewsnip case, bring it up. Preserve the issue for appeal, because my gut tells me that within a year or so, there is going to be a cert petition and very possibly an overruling of Dewsnip. I'm wondering, Jeff, if, oh boy,
That's
there
fine.
I go
Call
again.
me Jeff.
Judge Hopkins, do you have any gut feelings about this issue?
Well, it's interesting to hear your comments on the argument, because looking at DUSNEP and reading the rationale expressed by the court, one would think it would be a slam dunk. But we all in the bankruptcy community, when it was initially decided, we thought it was wrongly decided, and with our court being a plain meaning court as it's traditionally been for the last several decades, the statute itself is very clear. 506D says essentially the lien is gone after the bankruptcy's discharge is entered in the case. So it has a huge effect. I sat for a year in Florida, and one of the things down there that was causing such disconcertion or concern in the bankruptcy or in the community down there were these mortgages that were totally underwater, and this will certainly help.
I see. Well, let's move on to Bullard versus Blue Hill Bank. This was argued on April 1 in the Supreme Court. This is the question of whether there is more flexibility in allowing appeals from bankruptcy court decisions. This particular case dealt with denial of confirmation of a Chapter 13 plan. The First Circuit held that it was not appealable. Confirming would have been, but denying was not. There are 5 circuits that do not permit appeals, saying it's not final, and 3 circuits that do permit appeals, saying they are final. Justice Kagan commented in argument that the case was not particularly limited, using her words, by the text of the statute, so maybe we will not have a plain meaning decision. Some of the justices noted that there has not been any flood of opinions in courts that are more liberal in allowing appeals. And Judge Kagan said, for instance, that the fallback of allowing an interlocutory appeal on motion is unpredictable. This case, I believe, could have some rather larger implications because this is really the first time the Supreme Court has gotten into the question of whether or not there is a broader notion of finality in bankruptcy than in other areas of federal practice. Again, I look at Judge Hopkins, got it right this time. Is your gut telling you anything about that case?
Well, you know, Bullard it's a hybrid case when the underlying facts of it are really important and there's a split of authority with regard to whether or not you can use 1322B2 and 1325 to cure and maintain after the 5-year period. Unfortunately, the court's not going to get to that because it's going to really turn on this finality question. And 158, the statute for bankruptcy appeals, deals with proceedings and cases and whether or not a proceeding, which is a confirmation matter, is going to be a final appealable thing is already been decided by the court. And so to turn it on its head to say denial of confirmation is not in a final appealable order, to me, is troublesome.
Okay.
Well, isn't it also true that one of the rationales behind not allowing it or not making it final is that there's the opportunity for interlocutory appeals, but there's a limit on interlocutory appeals. Not only are they by permission, but I believe that you can only go to the district court on an interlocutory appeal unless you go directly to the circuit, in which case they're covered by the same rules as the bankruptcy court. I don't see how they cannot come down and say that there is a looser standard for finality. Otherwise, we'll get back to that old, very old Fifth Circuit view that until the case is closed, nothing is final.
Well, that would give you a lot of power, wouldn't it?
Well, it certainly would be nice. It would give the district judges a lot of power.
Well,
you're going to put debtors in a Hobson's choice, though. They have to promote and have confirmed a plan they don't want in order to get an appeal, which is a terrible position to be in because of Espinoza.
Well, listen, the 1st of April was a double header in the Supreme Court. There were 2 bankruptcy cases argued that day. The second was called Harris versus Vigalon, and this is a question of what happens with money in a Chapter 13 case that has not been distributed to creditors, and the case aborts. The circuits are split on that issue, and the Fifth Circuit said that the leftover money after the case aborts goes to the creditors in the Chapter 13 case. Justice Scalia said at argument, and this is important, that the statute does not say where money goes. So guess what, sports fans? This, I guess, will not be a plain meaning case. The bankruptcy judges looked around to try to find analogous law, and they latched on to revocable trusts, which I suppose might mean, if they go that way, that the leftover money goes back to the settlor of the trust, namely the bankrupt. Justice Kagan seemed inclined to favor the bankrupt, saying that congressional policy was to encourage people to try Chapter 13. And so if you take this money away from them, then that discourages them from Chapter 13. And get this, Chief Justice Roberts said that giving money to creditors would be an extra penalty on the bankrupts. So perhaps even the Chief Justice is on the side of debtors in this one, but time will tell. Now, tell you what, let's go on to circuit splits. We have 4 of them, really, that bubbled to the surface in the first quarter of this year. The first has to do with third-party releases in Chapter 11. We have a wide split. We have the 2nd, 3rd, 4th, 6th, and 7th circuits, now joined by the 11th, that do permit plans to give releases to non-bankrupt third parties such as officers and directors. And then you have the 9th and the 10th circuits that do not permit releases. Now then, Judge Lynn, Section 524E of the Bankruptcy Code tells us that the release of a debtor does not bar any claims against anybody else. So how come it is then that in bankruptcy there is the notion that you can have a plan with a release for third parties?
Well, the courts have said that the reason why you can have a release of third parties is that Section 105A allows the court to enter any order appropriate to the proceedings, the, as you call it, All Writs Act of Section 105A. The result of that is that since 524E does not specifically bar releases of third parties, that 105A allows the court to enter an order in appropriate circumstances that would permit the release of third parties. I think there are 2 things about the case that are kind of interesting. The first is the 11th Circuit cites a 6th Circuit test of 7 factors to be considered in connection with whether or not a release should be approved. This 11th Circuit then goes on to find that all the factors, or virtually all the factors, favor granting the release in this case. In point of fact, the 11th Circuit seems to overlook the fact that several of the factors cited by the 6th Circuit have to do with joint liability of the debtor with the party being released, such that release of the or failure to release the third party could give rise to an indemnity claim or similar claim against the debtor. In point of fact, the 11th Circuit says that those factors should be applied flexibly. And in Seaside, the case involved a company that provided engineering services. And as it happened, the parties who were being released were critical to the operation of the debtor. And 11th Circuit said since they were critical to the operation of the debtor, the factors pertaining to indemnity or another basis for asserting a claim against the debtor could be construed in favor of the release, notwithstanding that no claim could be asserted against the debtor under an indemnity theory or otherwise. The other thing that I find interesting about this and other release cases, for example, Pacific Lumber out of 5th Circuit, is that they seem to conflate what we used to call exculpation clauses with releases. A release, to my mind, is something that releases a party other than the debtor with respect to a claim that the debtor is liable on along with the third party, and that arose typically before the commencement of the case. An exculpation clause exculpates the debtor and its professionals and its employees from actions arising out of their conduct of the Chapter 11 case. this was the latter type of release in Seaside, and I think it is more proper to consider it under the old Barton doctrine that you can't sue a trustee without permission of the bankruptcy court, at least with respect to personal liability. And I think that the mistake here is that they're viewing post-petition pre-confirmation causes of action arising out of the conduct of the Chapter 11 case the same way they would a pre-petition claim under a guarantee or similar type of arrangement.
Well, I'll tell you what, we very well may have the Supreme Court weigh on this. This case is called SE Property Holding versus Seaside Engineering. That's on page 15 of your course materials. The losing side in that case did say officially that they are going to file a petition for certiorari. Hasn't been filed yet, but should be sometime before the summer. Now let's go on to another split of circuits between the 11th and the 5th Circuit. This has to do with res judicata from plan confirmation orders. The 5th Circuit said that for a plan confirmation to become res judicata in a subsequent action, it has to be sufficiently specific. The 11th Circuit told the 5th Circuit in their decision called Inter Iberia Bank, that by the way is at page 18 of your course materials, that the 5th Circuit forgot that their decisions actually had been overruled by a 2009 decision from the Supreme Court called Travelers versus Bailey. Any of you guys want to weigh in on this, or shall we move on? Well,
I think that the analysis of res judicata is correct in this case, and to the extent that 5th Circuit would disagree with it, I would be inclined to disagree with 5th Circuit.
Yeah, bravely said. All righty, let's move.
One hopes that Judge Stewart, Carl Stewart, is not watching this.
Well, let's move on to another case involving granting of damages for violation of the automatic stay. Take this particular situation. This is where we have a California District Court differing with the 2nd Circuit. Let us assume that you have a Chapter 13 case that was dismissed. During the Chapter 13 case, there was a violation of the automatic stay. The former bankrupt sues in district court for violation of the stay. We have Justice Beverly Reed O'Connell in Los Angeles who ruled that the district court cannot dispense damages. It has to be in the bankruptcy court. Judge Hopkins, does your gut tell you anything about this kind of a situation?
Well, we here have another split of authority. You got the 2nd Circuit in a case called Factory Point, holding that these kinds of cases can be brought in other courts other than the bankruptcy court. But I think I agree with the district court judge's decision here, because what we have going on is a state law claim brought under California law based upon the illegal foreclosure proceedings that violated the stay. And the district court essentially said that this is tantamount to a violation of the automatic stay proceeding under 362, and hence it should be in the bankruptcy court. Mind you, there's a 9th Circuit case that precedes this that holds that this is a preempted area, that any kind of claim brought in a state court or any other court is preempted and should be brought back into the bankruptcy court rather than the other courts.
Well, it's a very litigable issue. Now we're going to move on to another split that is also very litigable. We have the 9th on one side and the 11th on the other. This has to do with whether or not, when a bankrupt has to appeal an award for a stay violation, can the bankruptcy court award attorney's fees for the appellate work, or may only the appellate court grant the attorney's fees? If only the appellate court can do it, then very possibly you can only have a fee shifting if there was a frivolous appeal by the person who violated the automatic stay. So the courts are coming down on both sides of that one, and it just strikes me that this is an issue that anybody ought to take up anytime they have a chance, because you might find yourself in the Supreme Court.
I really think the Ninth Circuit stretches on this one, though, Bill. They're reaching out to the appellate rule. I think it's 38 that says that they have the ability to, on a frivolous appeal, award fees, and it's really not that case. It's really something governed, I think, more by the Bankruptcy Code statute.
Well, we're going to move on now to consumer and Chapter 11 cases. The first on consumer. This was a really gut-wrenching result. This came out of a district court in Florida. This case is called La Paz. It is at page 44 of your course materials. This is one where the individual was in Chapter 7. The trustee abandoned the home as estate property, which you would expect because it was over-encumbered. The bankrupt wanted to strip off an underwater mortgage, but the district court held that there was no jurisdiction in the bankruptcy court to strip off the mortgage after the home had been abandoned by the estate. Judge Hopkins, how do you come down on that?
Well, the court in its La Paz decision out of Florida cited the Dusnup case from the 10th Circuit, which the rationale used in Dusnup was actually affirmed without the Supreme Court commenting on it, that essentially the court, when abandonment occurs under 554, the property is abandoned and the bankruptcy court loses its jurisdiction. Now, there is a Third Circuit case that contradicts that. It's First Federal Savings versus Loan Association, both of which went up on appeal when Dusnup was decided. One of our authors here at Bloomberg, Margaret Howard, has actually written a note on this, which talks about the court's silence with regard to the issue that was actually before it, whether or not abandonment is tantamount to a loss of jurisdiction by the bankruptcy court. It seems to me here that perhaps the district court may be wrong, so we'll see what happens on appeal if it is appealed.
Well, that case, by the way, that decision didn't have much discussion, if any, about related to jurisdiction, because property of the estate is not the only basis for jurisdiction in bankruptcy courts.
Well, one wonders, I presume, that was the property claimed as exempt in part, and would this be generally true? Would this be generally true if property is exempted as opposed to abandoned?
Yeah, it was a homestead.
Right,
so,
it was a homestead,
so the
it was exempted.
Trustee's going to abandon it always.
Right.
Well, probably so, because any equity up to a given limit in Florida, I think in Florida you have a limit on the amount of equity. Yeah. It's unlimited?
Yes.
Well, so there's the fact is the court saying that jurisdiction is lost and make determinations respecting exempt property, because it would seem to me that would make Judge Hopkins' view even more apt, that perhaps the district court was mistaken in its approach to this.
Well, let's move on to, of all things, coercive tender offers, because, friends, in this brave new world of bankruptcy with hedge funds all over the place, we do have coercive tender offers in Chapter 11, most particularly in the energy futures case. And in that one, the bankruptcy judge, in the form of a settlement, allowed what some people called a coercive tender offer. This decision, as I said, in the energy future case, is at page 25 of your course materials. It was a tender offer for bondholders to basically compromise claims for a make-whole premium because the bonds were being repaid early. You could say that perhaps the facts in this case were kind of muddled, in the sense that the main complaint from some of the bondholders really had to do with things like the maturity of the bonds, which made the make-whole premiums very much different. But nonetheless, the offers to the two different bondholder classes were exactly the same. The argument was made that you couldn't do this outside of bankruptcy without supervision from the SEC, but the SEC was nowhere to be seen in Chapter 11, and this compromise was basically approved just as that, as a settlement. In fairness to the debtor and to the bankruptcy judge and the district judge where it was upheld, the creditors could opt out of this settlement. It was not being forced down their throat. If they didn't think it was enough, they very much had the ability to complain and continue suing for their entire make-whole penalty. This, I think, is an area where it is quite sad that the SEC does not appear in a bankruptcy case and have the government let its opinion be known about whether this sort of thing is proper or not.
You know, it's interesting that the court cited to Section 1109B as limiting the ability of the SEC to participate. I've always wondered, and I frankly suspect, that the SEC would have the right to intervene under Rule 2018A if it was necessary to protect its authority other than its participation in the reorganization process.
Right.
So I'm not sure 1109B applies here.
Yeah. Well, let's move right on to another consumer case, this in Chapter 13. This very well may be a case of attorney malpractice as much as it is bankruptcy, and that's what makes it a hard case. This is a situation in which the Chapter 11 plan promised creditors that the debtors would pay $812 a month, and at the end of the day, the unsecured creditors would have a recovery of 48%. Unfortunately, the lawyer had forgotten about a very large unsecured deficiency claim for a secured lender. The plan had almost been paid out. The bankrupts had paid $48,000, and they applied for a hardship discharge because they'd only been able to pay something like 15%, not the promised 48%, because of this, shall we say, unanticipated large deficiency claim, although the court points out that court is, by the way, the bankruptcy appellate panel from the Ninth Circuit, that the bankrupt and its lawyers should have known about this little problem for about 4 years. This case, by the way, is at page 39 of your course materials. And I'm going to put this question to both of you judges. Do you require plans to contain a statement about the percentage recovery that bankrupts are going to recognize through a Chapter 13 plan that's confirmed?
Well, our court typically, the plans do show an expected percentage, but it's not binding on the debtor. I think under these facts that in our district, the debtor would be entitled to a discharge, and not a hardship discharge, but the regular Chapter 13 discharge for having completed all the payments called for under the plan, which under 1328 calls for the discharge of the debtor.
Right, and same in our district as well. You'll see the trustee, the Chapter 13 trustee, insisting upon a percentage being put in there. But it's very common throughout the plan to see motions for modification downward based upon the facts that were here. The debtor's wife had cancer, the debtor's wife lost her job. There were a number of factors here that should have ruled the day, and it seems to me the lawyers simply missed the boat on it.
It was a very harsh decision, I think.
Yeah, that is for sure. It was a harsh decision, but bankruptcy is a tough world sometimes. Let's go on to Delaware. Back to Chapter 13. Can lawyers in major Chapter 11 cases in Delaware get a bonus? This comes out of the Fisker Automotive case. This case, by the way, is discussed at page 27 of your course materials. Here's the deal. Company goes into Chapter 11, says this business is a dog. We're lucky we got any buyer at all. And that buyer is going to pay enough so there will be a distribution of $500,000 to the unsecured creditors. The unsecured creditors committee says, whoa, hold up. We want to market this thing better. They got the case slowed down, much like Judge Lynn has done in some of his famous 100% cases. They did find a buyer, and get this, at the end of the day, there was about $40 to $50 million that went to unsecured creditors. In other words, a recovery about 100 times larger than at the outside of bankruptcy, due really to the fact that the committee's lawyers slowed down the case and found a buyer. They went to the bankruptcy judge for a bonus of about 50% of their fees. The bankruptcy judge said no, and that was bankruptcy judge Kevin Gross. He basically said, if you're charging $1,000 an hour on the top end, that implies that you are very, very good lawyers and you should provide very, very high quality legal services. So he denied a bonus. The lawyers had argued that, well, there was a great risk that we would recover nothing on our fees because this company looked so bad at the outset. Judge Gross observed that, well, frankly, there were law firms lined up down the street trying to get this case, so therefore, no bonuses allowed. Any thoughts?
The buyer in the case had been hanging around and they were participants. The lawyers had been around. The court asked a number of occasions, because they did this all around the holidays, which was one of the arguments they tried to use in order to enhance their fee. The court said, I gave you ample opportunity to make this process longer, but you chose this more rapid path, and it's not compensable on an enhanced basis because it's not necessarily a 100% case. And going back to our Sarko case earlier, typically courts will look to see what the dividend is going to be.
Okay.
Well, I think you noted in your commentary, Bill, that Nancy Rappaport, professor at UNLV, had suggested that the Judge Gross made bonuses contingent upon 100% satisfaction. I'm not satisfied that he made that a sine qua non for bonuses, but if he did, I would disagree with that, though I agree with the result based on the facts of the case. I think, as Jeff points out, pardon me, Judge Hopkins points out.
That's quite all right.
That the facts of the case were a little bit more complicated than the attorneys and other professionals involved would have you believe. For example, the buyer had been in an effort to get the company before, and then wound up coming back to the table and winning the company at a public auction. I don't think that there should be any factor that is dispositive. I think sometimes a 2% recovery by unsecureds may justify a bonus if other factors are met and if that is enough of an improvement on the result that would have occurred otherwise. I mean, there are some cases that simply aren't going to pay 100%. I don't care what you do. You can be an absolute genius and not be able to come up with a way to get to 100%.
Okay, Judge Lynn, this next one is yours too because it's your decision. Case is called Henry Fielding. This appears at page 40 of the course materials. This has to do about whether or not the bankruptcy court and the debtor really have the ability to tell the IRS how to apply distributions the IRS is going to get. Why is this an issue, Judge, and how did you come down on it?
Well, first of all, there's an energy resources case under Chapter 11 out of the Supreme Court that says that a Chapter 11 debtor may designate in its plan how amounts paid against tax claims should be applied. The issue is important in this particular case because if the IRS has the ability to choose how to apply payments on the taxes, then they will use them to pay secured penalty and interest as well as principal, whereas the debtor would only pay secured principal with first dollars, thus eliminating the possibility of further interest. I'm reluctant to comment further on the case. It's going to go up on appeal. The IRS gleefully told me at a motion for rehearing that they were taking me up on appeal, and it may go directly to the circuit because this would be a case of first impression in the Fifth Circuit.
Well, by the way, do you think your decision was right?
It's not one that's kept me awake at night, but I have my doubts about whether there were two bases for concluding that the payments should be allocated as directed by the debtor. One was based on the plan and the other was based on the fact that the payments were voluntary. I think the argument is pretty good that in a Chapter 13 context, any payments are voluntary.
Yeah. Well, this is a biggie. It's a big case for individual bankruptcy. It can mean a lot of money, how much relief you get out of the bankruptcy process. Let's move on to a Chapter 11 case now. This out of the Caesars Entertainment case. There were two official committees. There was the ordinary unsecured committee. This is actually kind of ironic. The debtor objected to having second lien note holders on the unsecured committee on account of their deficiency claims. So guess what? The U.S. trustee appointed a second official committee just for the junior secured bondholders who were probably mostly, if not entirely, underwater. The debtor goes to bankruptcy court and says, whoa, this is just wrong in the extreme. This committee ought to be deformed or disbanded by the bankruptcy court. And bankruptcy judge Golgar in Chicago said, frankly, I don't have power. I can't unform a committee that the bankruptcy court, that the U.S. trustee has used statutory power to form. Judge Hopkins, how do you think about that?
I think he's perhaps right. 1102 does give a bankruptcy judge some authority in small business cases and in some other cases to affect the committee process. But 1102 doesn't give the authority to disband, and there's no specific authority on that. The court in Detroit, Judge Rhodes, relied on Section 105 to essentially disband a committee. Judge Golgar disagrees with that politely and takes a very stringent view under the code of Section 105. 105 is going to be, I think, a biggie in some of the cases we've been talking about as they go up on appeal to see how, again, the court is going to view our authority under the All-Writ statute, as you put it.
Yeah.
I think that you could make an argument either way on that case because, of course, committees other than the General Unsecured Committee may be directed to be appointed by the bankruptcy judge, and therefore you may argue that if you can direct the creation of a committee, you can also direct the uncreation of a committee. I also think that this may have come as a rude shock to Caesars to actually lose a case when they got themselves out of Delaware where they might have had a better result.
Right. Well, next, by the way, I forget, that Caesars decision is at page 29 of the course materials. Next, we move on to a individual chapter or an individual bankruptcy issue, and that has to do with student loans. And the question is, do you have to exhaust administrative remedies before you can go to bankruptcy court and sue the lender for a discharge of student loan debt? This case is called Dorsey. It's at page 41 of the materials. And in this case, District Judge Susie Morgan from New Orleans said that no, you don't have to use the doctrine of administrative or exhaustion of administrative remedies. And she said that, among other things, may take a very long time before you can even exhaust your remedies. And furthermore, it may only result in a postponement of payment, not an eradication that bankruptcy allows you. And therefore, she permitted the lawsuit to go forward without first having the remedies tested in the administrative process. Let's move on now to mediation. This is brought forth by a case. Mike, how far is Houston from Dallas? About
240 miles.
Okay, well, 5-hour drive or more. This
was
not for a Texan.
Not for a Texan. You know better than that, Bill. You've been there. You've done that.
Okay, well, certainly less time than that on Southwest Airlines. In any event, bankruptcy judge Bohm in Houston, in a case called Smith, that's at page 37 of the course materials, said that he is no as he called it, mediation romantic. He laid down 10 standards that had to be applied before he would authorize mediation. Judge Boehm said it's really not true that mediation is always cheaper. He said also there are benefits, even if it is cheaper, to have a resolution in court, because, as he put it in substance, somebody who has been recalcitrant can be skewered on cross-examination, and maybe that sort of an experience will cause them not to be so recalcitrant again in the future. This is a case that has certainly caught the attention of judges all around the country. I'm just curious, Judge Hopkins, out in Ohio, where you work, are you a mediation romantic or not?
I suppose I am, and against probably the good advice of my colleague in Texas, in my view, mediation really works. I've seen it, I've done it myself, I've referred cases for mediation. There are certain points in litigation in the life of a case where a neutral will come in and really benefit the process. I don't have an issue with his holding in the case under 327 that a mediator is perhaps a professional, and I think he was somewhat offended because he was surprised by this tolling motion that was filed in the case, and to learn that the parties had already set up a mediator with a bankruptcy judge, a former bankruptcy judge. I have an issue with some of the language used because he's really making it virtually impossible for former bankruptcy judges in his district to serve as mediators.
Yes, and I gather much the same as you, Jeff. We do a lot of mediation for our colleagues, so that there's a lot of, I don't think it's so much that the parties mediating like us to do it because we're experienced. I think it's because we're free, and
right.
That makes us the price right. But I have some question about whether a professional that is not being employed by the estate directly, but is rather being employed by the estate together with, or the estate representative together with one or more other parties to mediate a conflict, whether that constitutes a professional under Section 327. I think you can make a pretty good argument that it's going to be almost impossible to show that a mediator is disinterested when, if he's employed by the estate, he's also employed by the other party, which means he has an inherent conflict from the beginning.
Catch-22.
Pardon?
Catch-22.
Yeah, catch-22. Right. Take the job and you're out of the job. Don't take, it's a real problem.
By the way, if you're really interested in this subject, there will be an entire hour-long panel at a seminar, the State Bar of Texas Bench Bar Conference around the end of May outside of Austin. Judge Boehm will be on that panel, I guess, defending his decision, and there will be some other folks who may take a contrary view. Now let's move on to another case where the reaction is, ouch, whoa, did this hurt a bankrupt? In the schedules, this individual bankrupt listed personal property as worth $950, said that this was done on advice of counsel. There was, unfortunately, a fire. The home burned down. The bankrupt filed a claim with the insurance company, and guess what? The insurance company, although the insurance company admitted that the cash value of the property was $50,000, said, no, let's follow the principle of judicial estoppel. The court agreed and said, yes, you swore to $950, and that's all you, the bankrupt, can get is $950. Interestingly, the court said that the trustee, who also made a claim on the policy, was not similarly bound because the trustee had not made any sworn statements about value. Now, listen, judges, we all know that valuations and schedules are kind of flaky. I mean, how the heck, when you schedule the value of your properties, can you really definitively figure out what it's worth? Is this a fair decision when the lawyer, in effect, said what the value ought to be?
Well, you sign those schedules under penalty of perjury, so you have an obligation to do that. But obviously, it happens all the time around the country. I think what lawyers are trying to do is get the value of the property inside the exemption provided by the state law so that the debtor doesn't have to come up with funds in order to satisfy creditors in a Chapter 7. It becomes a no-asset case. The Chapter 7 debtor gets the discharge and moves on with his or her life. In this case, obviously, it came back to bite. I agree with the decision in the sense that the Chapter 7 trustee shouldn't be stopped. For a very long time in this country, we were experiencing instances where the Chapter 7 trustees were being barred, themselves judicially stopped. And there's a case out of your circuit, the Reed versus the City of Arlington decision. The Fifth Circuit initially decided wrongly, in my opinion, to stop the 7 trustee, but then on a rehearing motion decided that the 7 trustee,
In bank.
oh, was it in bank?
Yes.
Decided that the 7 trustee was not stopped, even though the debtor who had failed to file a Fair Labor Standards Act claim and listed in its schedules, in his or her schedules when filing the bankruptcy, was stopped, but the trustee was not.
I think that this case provides another lesson that lawyers need to keep in mind when they're representing clients. This is just a second pitfall to causing your debtor to undervalue property. The first pitfall is the fact that, at least in my circuit, you're putting the debtor's discharge at risk because a certain number of mistakes in your schedules in the Fifth Circuit can result in a denial of discharge on the basis that you were reckless with the truth. So if you undervalue a lot of property in the Fifth Circuit, you may be putting your client's discharge at risk, and I think that might well be law that other circuits will pick up as well.
By the way, that case is called Brugge versus Metropolitan Property and Casualty. That was from East St. Louis. The case is discussed at page 43 of the course materials. The next one I'm just going to mention real briefly stands for what I think is a self-evident proposition of law. This arose out of the venerable Dow Corning reorganization. This came out of the Sixth Circuit, your circuit, Judge Hopkins, in January. The court said that a Chapter 11 plan cannot prescribe the standard for review on appeal. There was a part of the plan where there would be actions taken later. The company wanted it to be by abuse of discretion, and the circuit said, no, can't do it. You can't tell us what to do. You're just the parties signing a contract in the plan. Let's move on to another very interesting Chapter 7 case. That has to do with a trustee who sells property, and there is a credit bid. Let's take this situation, gentlemen. You have 2 people at auction. One is a cash buyer. The other person is the credit bidder, the secured lender. If the cash buyer gets it, the fee for the trustee is 2 to 4 times more than it might be if the credit bidder takes it. In this particular case, out of the Ninth Circuit,
Why?
Right. The issue was, or the decision was, you cannot count the credit bid in the fees for the Chapter 7 trustee. I suppose this must happen every once in a while. Anybody, you folks got any gut sense about this issue?
Well, the court lines up on it with the other circuits that have decided it. I think there's a case out of the Fifth and the Third Circuit, both holding essentially the same thing, that the trustee fee under 326 cannot include what is part of the credit bid. But as you say in your hypothetical, what if there are 2 bidders, one who is a lien holder and the other who is a cash buyer, and the cash buyer goes up to a certain amount and the lien bidder bids $1 over? All that work that the trustee has done is all for naught. I think the trial court here, who was reversed on appeal, the bankruptcy judge, was really reaching out to a beleaguered segment. Our Chapter 7 trustees haven't had fee increases in a long time, and they're now flooded with these informa pauperis cases, and BAPSIPA has put a lot more work in their plate with regard to these cases, and I think he was sort of reaching out to help that in that regard.
And I believe it was Judge Kaczynski who wrote that decision for the Ninth Circuit. He said the result may be harsh, but it's not absurd.
No, I would agree it's not absurd. I think that Jeff is correct, and I think that the issue becomes also to what extent is the trustee impelled to accept an offer that is in a lower amount because it's coming from the cash bidder, as opposed to the offer coming from the secured creditor bidding in the deficiency.
Yeah.
Because under those circumstances, there may be incentive to accept the cash bidder's offer on some ephemeral basis, simply in order to ensure that you're paid the full amount of your fee.
That case in the Ninth Circuit is called Tam. It's at page 45 of your materials. And to end, we're just going to mention this kind of briefly because this is the subject of an appeal right now to the Ninth Circuit. You will recall that the Commonwealth of Puerto Rico adopted a law which looks very much like Chapter 11. They had to do that because they have a power authority and some other government agencies that are almost bust. Puerto Rico, as you probably know, is not eligible for municipal Chapter 9 bankruptcy because commonwealths aren't. Only states are, and states only if their legislatures permit. District Judge Francisco Besosa in San Juan ruled that the Commonwealth law on the subject of municipal insolvency was basically preempted by Section 903 of the Bankruptcy Code. I would love to talk about this for another hour or two, but as I said, there is an appeal pending right now. I think you're
In the First Circuit.
Right, and I think you said that one of your treatise colleagues,
David
Judge
Skeel,
Skeel.
Professor Skeel, is writing on. He wrote the
yes.
brief on behalf of the Commonwealth of Puerto Rico.
Well, and what I really find interesting about this subject is whether there is a residuum of sovereignty that states as well as commonwealths have that would allow them to use their own state laws if they don't want to use the bankruptcy program. That was not an issue that Judge Besosa discussed much, but methinks that the issue of sovereignty and retained sovereign powers ought to be worth some discussion in the circuit.
I'd agree with that.
Agreed.
Well, I guess we'll find out in due course. Well, that is our discussion of hot cases from the first quarter of 2015. We'll be back again around the end of May. Probably by then, we may have 3 decisions from the Supreme Court. So we'll talk about them at the end of May, or certainly in June or July on these shows. Meanwhile, I would like to thank our panelists, Chief Judge Hopkins from the Northern District of Ohio, D. Michael Lynn from the U.S. Bankruptcy Court for the Northern District of Texas in Fort Worth. Thank you both very much for being with us.
Thank you for joining us on Eye on Bankruptcy, brought to you by the American Bankruptcy Institute and Bloomberg Law. Please stay tuned for a live Q&A with today's panelists.